Hey guys, how you doing? I've already got the brown dog is back here crying because I made the mistake of saying my WALK. But hey, listen, guys, please hit that subscribe, hit that like, please share this. Don't forget. Here we go. We're gonna do we're gonna cover what this hip pocket service is. If you found this, it's probably because you're following the Nick Rekieta's latest lawsuit. Happenings and probably heard this term. And our good buddy Volstorm sent this to me. So let's go over this real quick. This is from a law firm in Minneapolis. And this is something that not every state has. So I think it's unique. There's parts of it I like and I don't like, but let's just go over what they say here. Hip pocket service in Minnesota. Everybody knows what service of process is. It's how you instigate. It's you file your suit, you file anything, and then you have a someone who is affiliated with the court, usually like the sheriff, or you can do it yourself. File service, and then you return the receipts to the court. So that way, if the the opposing party, doesn't answer, then they are held in contempt. In Minnesota State Court, unlike most states, a civil action is commenced upon service of the summons and complaint, not by filing. This is known as hip pocket service. If you or your client is served with a summons and complaint with a Minnesota State Court option or caption, excuse me, and no court file number, do you have to respond? The answer is yes. You must answer or otherwise respond to for example, with a motion to dismiss within 21 days, or obtain an extension, or you will technically be in default. This is what probably brought you guys here. It's Montegraph or something like that is suing Nick Rekieta. I don't know the parties involved, and I just know that questions about the rules get asked to me, and so I gotta put my parents' good money they spent on sending me to law school to use somehow. Default judgment is not automatic, and it can be vacated, but you should not ignore the Minnesota summons and complaint just because it was served but not filed. Actions in federal court in Minnesota are commenced by filing pursuant to the federal rules of civil procedure. Federal rules don't have this. So if it's a federal case, you got to follow their rules. This is specifically for Minnesota rules. Every state has their own rules. Every district within that state may have their own rules, and even your local courts within those districts may have their own rules still. Court goes back to, the back to common law, 1600s England. That's why this stuff works so well in America. Because the case is commenced upon service in Minnesota, any applicable statute of limitations is told as the date of service. The plaintiff may choose to file immediately after obtaining an affidavit of service, or the defendant may file the case with the applicable court, but often neither party has a strong incentive to file right away. Surprisingly, at least to some, the parties may even serve written discovery and take depositions in a non-final case. Often these cases are settled without ever having been filed. I think the idea there is that the two sides they want you as the attorney to be the uh, mediators between two sides, which really it should be. Attorneys, excuse me, there. I didn't realize my notifications were on. Are the uh, first line of defense as court officers, much like a police officer is an officer of the court. Why would a party not want to file a case? The primary reason is that until the case is filed, it remains out of public eye and is otherwise confidential. That's a biggie right there. I mean, you realize, like, if you're late on your mortgage, or if you're like, uh, late on a child support payment, something like that. Anything that gets filed that immediately triggers action in court, all that stuff gets entered immediately. And it's like, wait a second, you know, I was out of town. The stamp fell off, or I didn't put a stamp on the envelope. There's a lot of innocent things that can happen. It doesn't mean that you're automatically in the court system, doesn't mean that you're automatically at wrong. But in our society, we're quick to judge. And if you go to court, it's like, oh, that's horrible. You know, oh, like this person, they did this. It's like, I mean, maybe it was just a mistake. Maybe it was a mistake on the other side. Who knows? Chill out about this. Remember, don't pass judgment. Wait until there's a judgment filed. Let's see here. Why would a party not want to be filed? A case, keep it out of the public record. And starting in 2021, pleadings in Minnesota State Court civil cases can be publicly accessed on the internet by anyone. Because lawsuits sometimes involve embarrassing or private information involving a case without filing it may be appealing and may even be an incentive for settlement. Hip pocket service means a plaintiff may serve one or more defendants and keep the complaint in his pocket rather than making a public filing. Harris v. Chase Bank. Oh, that's what I was talking about. Not filing also saves filing fees and reduces the burden on the courts. That is a big one. According to a law review article, Minnesota is one of only 3 states in the union, along with South Dakota and North Dakota, which is funny they're all 3 together, which is possible to commence an action, engage in lengthy discovery, and reach a settlement without ever filing. Minnesota's rule dates back to 1851. It is currently found in Rule 301A of the Minnesota Rules of Civil Procedure, which states civil action is commenced against each defendant when the summons is served upon that defendant. Service can also be effectuated by sending a summons by mail and receiving back a signed acknowledgement or delivering the summons to the sheriff where the defendant resides, so long as the sheriff actually serves the defendant within 60 days thereafter. The requirement of Rule 504 of Minnesota's Rules of Civil Procedure, although hip pocket service has existed in Minnesota for over a century, effective July 1st, 2013, the Minnesota Supreme Court put a constraint on this concept. Rule 504 was amended to include the following language: a deadline for filing action. Any action that is not filed with the court within 1 year of commencement against any party is deemed dismissed with prejudice against all parties. All parties, that's interesting. Unless the parties within that year sign a stipulation to extend the filing period. So this is, you get into an argument with your neighbor, you file a suit against them, you better have everything fixed within a year. And if one party disagrees, then it's a you no longer get the benefits of the hip pocket service. You have to go to court, it sounds like. This paragraph does not apply to family cases that governed by Rules 301 to 378 of the General Rules of Practice for the District Courts. This means that the action must be filed within 1 year of service or it will be dismissed with prejudice. This is a very harsh consequence, so plaintiff attorneys availing themselves to this process must be very careful to keep this deadline in mind. Huh. Any deadline not commenced within a year against any party is deemed dismissed. Any action that is not filed with the court. Interesting. Yeah, I'm wondering. I was trying to see if that language could be read to explain to me what the thought process is on the plaintiffs in this case. Look, here's what it boils down to is that, yeah, you'll hear hip pocket service. It's still a viable option in the court. This is the state of Minnesota. Remember, 57 states don't have it. Minnesota, South Dakota, North Dakota probably make about 1 or 2% maybe of the entire U.S. population. So a majority of people will not have this type of levity with the courts. It's just a It's just a style of doing things. And this is what's great about this is why jurisdictions are such a big deal, why counties are a big deal, why circuit courts are big. It's things like that. It's a very complicated and lengthy thing that's been going on for hundreds of years since the beginning of the country. It says before the beginning of the country. And this is why, if you are licensed to practice in one state, you usually aren't licensed to practice in another state. That's very, very rare. So remember, if somebody's a lawyer in the state next to you, uh, if they're an attorney over there, they are not an attorney in your state. But anyway, that's it, guys. So if you have any questions, leave them in the comments. I'll try answer best I can. But this is just the Minnesota Rules of Civil Procedure. It's kind of a cool deal, the hip pocket thing. It's interesting. It's a good way to help uh, relieve all the pressure that's on the court system. Anyway, guys, I'll be seeing you soon. Till later, don't forget to subscribe, to like, and Godspeed, everybody.